It truly is an honor to be here. I was here a number of years ago, and my son is now 16. And do you remember that? So I think at the time, I had nobody to watch him, so I actually brought Gregory with me. And he sat right here on the chair on the stage here for the whole time I was speaking. And that's never happened since until, today, my wife is in Florida, and I have a 5-year-old, probably the same age Gregory was. And my older daughter had a practice thing, and I'm sitting here waking up this morning, my goodness, I've got Samantha's tonight, and I have to bring Isabella with me and have her sit on the stage like I did 10 years ago. But the older daughter's practice got moved, so they're home together. So it's working out fine. She's 17, so everybody's safe, I hope. Exactly. So yes, I am an elder law attorney, a certified elder law attorney. And what that means is all I do is help folks deal with care issues and the legalities of growing older and protecting assets, preserving income, protecting their wishes. And the most important thing that I believe we do is we do all we can to help people stay at home as safely as possible and for as long as possible. That doesn't happen all the time, and sometimes care is needed, whether it's assisted living or, of course, facilities. But I wasn't always going to be an attorney, and I wasn't always going to do elder law. I actually was going to be a cop. That's what my plan was. I got my associate's degree, I got my bachelor's degree, all in criminal justice. I was going to be a police officer. My grandfather, however, and of course the man upstairs, had other plans. My grandfather was a lawyer, practiced in Brooklyn for decades. And when I was about 19, I met with him one summer day I had visited, and he sat me down and said, "Brian, we would like you to go to law school." And that changed my entire life. And I liked the idea because I liked school. So I kept going, applied to law school, made it into law school. And as I was heading towards graduation, I'm saying to myself, what am I going to do? What kind of law am I going to practice? Well, the reality is I grew up blessed with 2 sets of wonderful grandparents. My mom's parents lived right next door to us in Malvern, and my father's parents lived in Lynbrook, about 5 minutes away. To keep it short because of time, I can't explain the amount of care issues that we went through between all 4 of my awesome grandparents, from the cancers and the wheelchairs and the diabetes and the dialysis, the hospice, the caregivers. From 10 years of age until 33 years of age, something was always happening. So, and we've been there. We've all had family members, we've had friends deal with these issues. But as I was approaching the end of law school, the reality is, what type of law am I going to practice? Well, I really only had one choice. As I learned about this elder care issue and learned that there's a way to help other grandparents, that was really what I had to do. So I started practicing January of 1998. So it's going to be 21 years in January that I've done nothing but deal with these care issues and the planning and the protection of other people's grandparents. And I thank God that it's been that way, and I thank God for hopefully the next 20 years. Well, maybe not. Maybe 10 more years. And then go retire someplace. Anyway, so what I want to convey to you today, and I think everybody here will agree, is that when it comes to caring for a loved one, typically an elderly loved one, but when it's caring for a loved one, it's about protection and it's about the care. And so to share how that plays out in what we do every single day, I sat with a 82-year-old woman about 8 years ago, and she had come to us distraught because her husband, the Alzheimer's had progressed to such a point that she needed help in the house, which of course happens. And it's always wiser and more prudent to reach out before there's a real crisis so that you can get help before the crisis occurs. And we're meeting with her, and I'm speaking with her, and we're hearing the progression. But the reality is that she had already hired another law firm to help to get what's called community Medicaid into the house. And when somebody needs care in the house, it can be very, very expensive. And Medicaid is a program that will actually pay for an aide to come into the home and help with what's called the activities of daily living. And that aide will be there, paid for by the county and the state, and actually help with the walking and the bathing and the toileting and the dressing. And she knew she needed that help. So she went to this law firm that she was recommended to. As they're going through that process, because it's not easy, she realized that she can no longer care for her husband at home. And she wanted to talk to that attorney about a nursing home. So here she was dealing with the legalities only. And when she went to this other law firm to deal with care issues, and when she needed help with care issues, that other law firm wasn't able and willing to unfortunately help with those care issues. They just wanted to focus on the legal and the financial. She was sitting in my conference room talking about the care issues because that's what we specialize in. And we were able to walk her through that process, and we have a social worker on staff who's able to assist with those decisions to deal with that progression and to deal with facilities and which ones are good and which ones are better. So here was a woman in need, only focusing on the legal side of things for a number of months and realizing she needed to focus more on the care side of things. On the other side of the coin, we had a gentleman come in. Again, 80s. It seems to be an 80s thing, although we do work with folks in their 60s and 90s and hundreds. Not 110. Never had that happen yet. But this gentleman had done all he can, but in reverse. He had spent so much money caring for his wife to keep her at home. He didn't even think about the legalities. He didn't even think about the money. All he focused on was the care. And God bless him and all that he did do. But he came to the same conclusion, the woman I had mentioned earlier, that he could no longer care for her at home on his own. So he also sought out a nursing home. Again, not even focusing on legalities and protection, he did the Medicaid application himself. And you don't know what you don't know. And he filed that application and he got an approval. However, it didn't take very long for Medicaid to catch up to him and say to him, you know what, you missed this step and this step and this step, and now you owe us over $40,000. So there was a man, and I would hope that I'd be like that, in that all he was doing was caring for his wife and making sure she was safe and at home. But we also have to be wise and look at the protection side. So what we do and what other elder law firms should do is focus on the legalities of protection and the realities of the care. That was good. Write that down. The legalities. Okay. Very good. So what I want to share with you for the time that I have is how best to do that. And what we do is we break things down into three: planning, protection, and provision of care. Okay? Plan, protect, provide. And on the planning side of things, it's always, always important that every person have a basic plan in place. A basic plan in place includes 4 documents. It's not very difficult, but it's worth its weight in gold, and I'll explain what those 4 documents are. The first one is a last will and testament. And we've all heard of a last will and testament. We know what that is. That is the document that will distribute your assets after you pass away. It's what people have said for years. It's not so much anymore, but it has been the cornerstone of any estate plan, so that you can have that document. And quite honestly, people call me up and say, well, I have a will. I don't need anything else. And that couldn't be farther from the truth. A will, which I'm not going to get into the depth of it tonight, can cause more problems than it's worth, because you have to go through the probate process in order for that will to be valid, to determine whether the will is valid. So a will is again, the first basic document anybody should have, everybody should have. The next document is called a durable power of attorney. That's the document, and quite honestly, that one is worth its weight in gold, because that is the document where you can appoint one or two people to help you with your financial decisions, to deal with the protection of assets, to protect income, to apply for government benefits. Everything financial and anything financial that you could do yourself, your power of attorney agent can do for you, provided that power of attorney is the right power of attorney with the right language in it, okay? To take a moment to explain the history. New York State has had various forms of the power of attorney form itself. They changed it a couple of times pre-2000, and they changed it again in 2009, and changed it again in 2010. So the form, the base form that the power of attorney has to be on is the 2010 form. That's complication number one. Number two is the form is broken into two parts. There's the main part where you say, my agent can do A, B, C, and D. And then there's the second part that says, my agent can make gifts for me. It's called a statutory gift rider. And people kind of give you a little look when you say that, because why do you have to worry about your agent making gifts for birthdays and Christmas and so forth? That's actually the most important half, all right? That's the part where your agent can actually protect your assets. So if a care issue crisis should occur, it's through that gift rider to the power of attorney where that house can be moved out of your name, where that income can be protected. All right, so again, has to be the 2010 form. It has to have the gift rider. The next part, there are modification sections in each of those two halves. Those modification sections must be completely expanded. All right, if the modification sections are not modified, then that power of attorney is going to be lacking in a lot of potential powers to help in an elder care or aging situation. All right, so that's the third part. Post 2010, have to have the gift rider half, and you have to have the modifications. The other caveat is, don't do Susie Ormond's forms. Don't go to LegalZoom. Don't go to Staples. All of those forms are going to be generic in nature and not tailored and not modified, okay? Twice a week, I'll be fair. Twice a week, we sit with powers of attorney from other lawyers. It was a real estate attorney. It was a son-in-law. It was a neighbor. And they did a power of attorney for their client. And it's lacking in what's built into it. All right, I've spent a couple of minutes talking about this because it is the most important document. You need somebody that does elder care and does estate planning for a living to build your power of attorney document for you. All right, the other two documents, healthcare proxy and a living will. Rather briefly, the healthcare proxy is where you can appoint one person to make healthcare decisions for you if you can't do it yourself. If you can still communicate a wish or desire to a doctor or to a healthcare team member, they will listen to you. If you can't do that due to anesthesia or due to an incapacity, diminished capacity, then your healthcare agent can step up and make the decision. All right? Very important document. The one caveat there is you can only have one at a time. You cannot say, I pick my son Bobby and my daughter Judy to be my healthcare agents. Not allowed. You have to do one at a time. And we've seen those a lot, okay? Last document is a living will. While the last will and testament and the durable power of attorney and the healthcare proxy are required, in my opinion, the living will is your choice. The living will is a document that doesn't appoint anybody, but it's a statement from you that says, if I'm in an irreversible condition, I do not wish to have medical treatments that will merely prolong the dying process. In other words, if the good Lord is taking me home, let me go. I don't want ventilators. I don't want respirators. I don't want feeding tubes. If it's at that point of no return, then let it happen. We do those documents as two separate documents so that the living will can stay home until the healthcare proxy agent is ready to bring it up for discussion. Some attorneys do it as one document. We don't like it as one document because living wills have been misinterpreted, and doctors and nurses, as we all do, can make mistakes as to what a living will actually means. There's been studies on it. So keep the living will at home until that time has drawn near. Now, apart from those 4 basic documents, and again, those 4 basic documents are for everybody, regardless of age, regardless of health. As we go through other issues, other family or factual circumstances, if there's a minor beneficiary, if there is a beneficiary going through a rough marriage and a potential divorce, if there's a child who's incarcerated or has an addiction, all of those factual issues come to bear upon the planning process. And they have to be dealt with, and they have to be accounted for in the documents. I can't get into all the details as to how to do that in our time, but the reality is there's something called a trust, okay? A trust is something that can be built into the plan so that the money can be managed for that beneficiary, okay? So it's very important something like that is included if you have any of those circumstances. The vast majority of work that we do deals with the aging population, deals with grandma and grandpa, mom and dad, husband and wife, over 60, 65 years of age. And what they're doing and what they're coming to talk to us about is, well, you know, mom went through this and she ended up in a nursing home and they wanted to take the house. Or dad ended up with home care and they tried to put him in a nursing home and we didn't want it. And we don't want those things to happen to us. So those types of issues, I think every family has been through or seen something from a distance about that. So we help families not only do the planning, but to protect. And why do we want to protect? Why do we need to protect? Because of this thing called care. Now, what is elder care? Elder care is very different than medical, all right? There's medical needs, and then there's elder care. Other words for elder care are long-term care, or custodial care, or chronic care. Again, custodial, chronic, long-term, elder care, those are all the same thing. And what does that mean? As we get older, like the stories I shared with you earlier about the husband and then the wife, forgive me, the wife and then the husband. No, the wife and then the wife. As we get older, we might need help getting up and out of a chair. We might need help walking. We might need help bathing. We might need help toileting. Those are called activities of daily living. Okay? Those activities of daily living are not medical needs. Okay? They're custodial or chronic or long-term. And since they're not medical in nature, then your health insurance doesn't pay to give you the help with them. For example, if somebody were to go to a hospital or an emergency room or a rehabilitation facility, that's medical in nature because the doctors are involved. And there's prescriptions involved, and it's medically necessary. So therefore, Medicare and Medigap policies, Medicare supplemental policies, all of them will cover it, subject to copays and so forth. But when the needs are chronic or custodial in nature, there's no medical insurance. You may have something called long-term care insurance, but that's a very rare policy, okay? We don't see that a lot. And if you do have it, sometimes it's not robust enough to cover all the needs. So the other ways that you pay for that type of care is using your own cash. So you can have an aide come into the house. You can pay them $10, $12 an hour cash off the books. We don't recommend that, but we do know that's what kind of makes the world go around in the beginning. The reasons we don't like that is because of insurance reasons and liability reasons and so forth. But if you bring in an agency, you're talking about $20 to $25 an hour for home care. That can run up to $6,000 to $8,000 a month. In a nursing home, you could be looking at $14,000 to $20,000 a month. So paying for long-term care privately with your own cash can be done, but most people don't want to do it, and they can't do it. So then we're left with this Medicaid program. All right? So Medicare is health insurance for medical needs. Medicaid is the program that will pay for home care and will pay for nursing home care if necessary, subject to, provided you are actually eligible. All right? It's a government entitlement. And what that means is you have to become eligible, and once you're eligible, then you're entitled to it. Everything in the Medicaid world to pay for the care is based on assets and income and health. Okay? The health side of things, just to cover that one quickly, we'll assume the person has the health care needs in order to be eligible. Assets and income. That's the protection part. And what can we do to protect the assets so that the person becomes eligible for Medicaid as soon as possible? And what can we do to protect the income so that we don't have to lose it all or pay it in to the system? Well, to guide us through that, it all depends on what type of Medicaid we're talking about. If somebody's going to be staying at home, the rules are different than if somebody was to go into a nursing home. The two biggest differences, all right, it's what's called the 5-year look back. And the 5-year look back, thank God, only applies to nursing homes, all right? And what that means is, if somebody was applying for care in a nursing home, the Medicaid application process requires 5 years of review of every aspect of their financial life. If it's a husband and wife, it's both of them, for 5 long years. Now, why 5 years and what are they looking for? Well, what Medicaid is looking for is they want to know what you've done with your money if you have intentionally and deliberately taken steps to protect your money so that you can save it for the family, but then get Medicaid to pay the bills. So the 5-year look back is the first difference between the two Medicaid programs. The second big difference are the penalties, okay? So when somebody is applying for Medicaid in a nursing home and they've submitted their 5-year review, their 5-year look back, and hopefully they're working with an experienced elder attorney to kind of navigate all of the pitfalls. What often occurs is there's going to be a transfer. Let's say it was a $10,000 transfer to son Johnny to help him, pay for the roof. Or if there was a tuition payment or different charitable, okay? There's rules for all those types of gifts and transfers. But assuming it was something families do quite often, which is they try to protect the house or they try to protect the money. So let's say mom and dad put $100,000 in their son's name. What happens is, if that was done within the 5 years before going into a nursing home, there will be a penalty based on the amount of money, okay? And the penalty is time. What Nassau and Suffolk counties say is that for every $13,000 worth of money that is protected, they will not pay, Medicaid will not pay for the nursing home for 1 month. Okay? So I used a $100,000 example. $100,000 divided by $13,000, you're going to end up with about 9 months, right, accountant? Is 7? Thank you. Okay. So you'll end up with a 7-month penalty in which Medicaid won't pay for that nursing home. Okay? That's something that has to be dealt with and hopefully planned out so something like that doesn't occur. Those are the two big differences between nursing home and home care. In a home care setting, there is no 5-year look back. That means we can get care, we can make somebody eligible very, very quickly and move money around and not have it subject to penalties, okay? So gratefully, we have clients come in November and there is a home care need and we need the care as soon as possible. We can actually, if we have enough time, move money around to make mom eligible for home care and not have a 5-year look back and not have a penalty period. So therefore, we can have eligibility December 1st, okay? So home care in New York is a wonderful program. Since it is a government program, though, these applications can take about 4 or 5 months to get approvals. And they're not easy to obtain, but it's entirely achievable. Now, if somebody's applying, just some rules as I kind of wind down on some time. The rules as far as assets and income. A person applying for Medicaid, either home care or nursing home, has to have less than $15,150 in their name. Okay, 15,150. They are allowed to have a house in their name. However, we don't want a house in their name because then Medicaid can get it after they pass away. Okay? They're allowed to keep an IRA. So if there's a $200,000 IRA or 401k, that is entirely able to be kept. On the income side of things, if somebody's going to a nursing home, they're allowed to keep $50 a month. The theory there is if you're going to the nursing home, you're not going out to Atlantic City to spend it all. So what they say is $50 a month for that. Now, in a home care situation, it's a little more complicated. A person applying for home care Medicaid, to get an aid in there to help, is allowed to have $865 a month. Now, the good thing is, they don't have to lose everything over the $865. We're able to shelter the income over the $865 by utilizing something called a pooled income trust. For example, if mom has $2,000 worth of income, she gets to keep her $865. She also gets to keep her health insurance premiums. And let's say that's $150. So now we're at, let's say, $1,000. So we have $1,000 extra. Every single month, the $1,000 in overage income has to go into this type of pooled income trust. And we can then use that, the family uses that, to help keep mom at home. So you could pay the real estate taxes, or you could pay the rent, or you could pay the utilities. Any bills in mom's name can be used, all right, can be paid. So again, the home care program in New York is a wonderful program considering what else is out there in other states. Now, last parting thought. When it comes to planning and protecting, timing is everything, all right? Timing is everything because of that 5-year look back. The number one tool that we have to help people plan and protect is something called an irrevocable trust. When I first started practicing law back in 1998 and 1999, I was a little intimidated by these trusts, especially the irrevocable part. And clients even today share that. Irrevocable trusts, bottom line is, it is a protection tool that allows you to actually keep a lot of control and a lot of flexibility. I'll give you an example. If the number one asset that we protect for families on Long Island is their home, okay? And the irrevocable trust is the best way to do that. What happens is the home would get transferred into this trust. And by the way, a trust is nothing more than a written agreement. That's all a trust is. And it's between, let's say, mom, who is what's called the grantor or the creator of the trust, and let's say daughter, who's trustee. It's a written agreement between the two of them. And what that trust says is, while I'm alive, mom, I get to live in my house for the rest of my life. If I become incapacitated, I still want to stay in my house, but if I can't, then you guys could do whatever you got to do to put me into a facility to get the care that I need. But when I ultimately pass away, that third stage, the trust will then distribute the property to your beneficiaries, just like a will does. Okay? So a trust is not some highfalutin, wealthy person-only type of document or strategy. It's for everyday families, and it's just a written agreement. So that written agreement, again, primarily with the house and the flexibility that and the control that it gives you, it'll say flat out, I've got the right to live here. Nobody can kick me out of my house. All right? I can sell the house. My trustee can sell the house for me if I ever need that done. That's important because that happens sometimes. In addition, you get to control who that trustee is. All right? So if there comes a time when that trustee is no longer the favorite child, you can actually fire them. All right? You may never have to do it. I've seen it maybe 3 times in 20 years, but it's good leverage to have just in case. In addition, and I got this objection years ago, but it still pops up, I don't want an irrevocable trust because what if I want to change my beneficiaries? Irrevocable means I can't change things, right? And the answer is no. The way the trust should be drafted is that it allows the client to change who the beneficiaries are even after it's in force for years. So for example, if I say, I want my 3 kids to inherit my assets equally, but then you realize a couple years later, those grandkids, they sure are the best. I want them to get something. Or, God bless you. Or I want to include something from my church. Or that daughter doesn't visit anymore. I want to, lessen her percentage. You can entirely change all of those beneficiaries. And that way you keep control over who inherits and you can even control when they inherit. All right? So I'm running out of time of my portion, and I'm excited to hear Bobby's portion again as well. But I want to encourage you, if you haven't undertaken the planning and the protection, really get that done, okay? We at our office offer free consultations. Most firms do, all right? And I encourage you to go see somebody that's experienced. Don't see an attorney that does criminal and bankruptcy. Oh, and I do elder law too. It's all I do every day, and there's not enough time in the day, okay? So we'll be back. If you have any questions, write them down, but we can answer some questions at the end, okay? Thank you very much for your time, your attention, folks. I would like to introduce Bobby Bambino. I have had the pleasure and the honor of knowing him for a number of years, and he's a good man. So let's hear what he has to say about the spirituality component of aging and caregiving. Thank you.
Thank you, Brian. Thank you, Samantha. It's an honor and a privilege to be here tonight. I'm handing out some fill-ins. We thought that it would be a good idea, since we have a short amount of time and a lot of area to cover, that if you had something to take home with you, it would be great, because we won't be able to spend an exhaustive amount of time on this really wonderful topic. Excuse me. What we're going to do tonight is we're going to kind of start at 30,000 feet with some overriding concepts and things that we really need to establish in our hearts and in our minds and in our souls, and then we'll get down to some practical stuff towards the end. And the first thing I want to talk about is cultivating a hope-filled life. Now, that may sound like you've already got that down pat, but the operative word there is cultivate. Okay? It's one thing to understand, to believe, and to have. It's another thing to cultivate. Caring for the chronically ill puts us in touch with the brokenness all around us. That's your first fill-in. Caring for the chronically ill puts us in touch with the brokenness all around us. I'm going to just go on with the next fill-in. Even though we are whole, we have a sense that things are not what they ought to be. We understand this through Romans chapter 8, 19 through 20, talks about how all of creation was subjected under man, and it is waiting for the revelation of the sons of man to be restored. So we understand that things are not what they ought to be, but they're going to be restored. Listen to these words in Revelations 21, 1 through 5. It says, "Then I saw a new heaven and a new earth. For the first heaven and the first earth had passed away, and there was no longer any sea. I saw the holy city, the new Jerusalem, coming down out of the heaven from God, prepared as a bride, beautifully dressed for her husband. And I heard a loud voice from the throne saying, 'Now the dwelling of God is with men, and he will live with them, and they will be his people, and God himself will be with them and be their God. He will wipe every tear from their eye. There will be no more death or mourning or crying or pain, for the old order of things has passed away.' He who was seated on the throne said, 'I am making all things new. Now, Jesus actually, that was from Revelations, but Jesus introduced this idea to us in Matthew 19:28. Jesus said to them, it says, I tell you the truth, at the renewal of all things, when the Son of Man sits on his glorious throne, you who have followed me will also sit on 12 thrones, judging the 12 tribes of Israel. What sin has corrupted, you see, through disease, God will restore. Understand, he says, I will make all things new. He doesn't say I will make all new things. It's just a little bit of a difference there, but it makes all the difference, doesn't it? I will make all things new. This is why we remember our loved ones. So we must cultivate this idea of having a hope-filled life to which we are going to. I often say that we spend a lot of time understanding what we've been saved from, my wretchedness, my prior life, but we don't talk a lot about what we've been saved to. And that's where we have to begin to cultivate this understanding that this is not all there is. And there is so much more, so much more. So how do we do this? By understanding eternity. Ecclesiastes 3:11, another one of your fill-ins. Ecclesiastes 3:11 says, God has put what? Eternity. Where? In the hearts of men. Hebrews 13:14. For here we have no continuing city, but we seek the one to come. Psalm 23, one of our favorite Psalms, right? Verse 6, what does it say? Surely goodness and mercy shall follow me all the days of my life. And what? I will dwell in the house of the Lord forever. Amen. Eternity. We have to cultivate this hope-filled idea of what eternity looks like. So how do we do this? How do we do it? Step number 1. I'll give you 3 steps. Establish ourselves in eternity. Because of Jesus Christ, we will live eternally in his presence and will see him make all things new. That's the important part there that I want you to grasp now. We will see him make all things new. So we establish ourselves in eternity. We cultivate this idea. Step number 2, we reestablish our present through faith. Faith positions us in our present, not just our being, but also who we are as children of God, holding on to the promises of God. We understand this from Abraham, right? Abraham was given a promise. Did it come to pass right away? No, it took 10 years. But he lived in his presence as if his future was a reality. And that's what we need to do. Our future in eternity is a reality that has to be lived in the present. When we begin to do this, we we have to live. We have to cultivate the idea of eternity and live in the present as if we know what our eternity is.
The future is a reality.
And as if the future is a reality, because it is. As Abraham did. So step number 3 is to refocus our hope. Now, it's very important for us right now to make sure we understand the definition of hope. Years and years ago, I really was struggling with this idea, Christ in me, the hope of glory. What is it in 1 Corinthians 13? The last verse says, and these 3 things remain, faith, hope, and love. But the greatest of these is love. So what is this hope? What is it? You know who helped me with this? Merriam-Webster. Hope defined. Hope is, listen to this, the positive expectation that something good is coming. You see, we often live in hope like the little kid who wants a bicycle for Christmas. I hope I get it. I hope. He's not really very sure, is he? That's not biblical hope. Biblical hope is sure. It's expectant about something that will come to pass. So how important is hope? Well, as I spoke about in 1 Corinthians 13:13, faith, hope, and love. Now, faith establishes our present. We spoke about that, right? Abraham established his present in expectation of his future. So hope propels us to our future. I stand in my present with an expectation of the future God has for me. And then, of course, love. The greatest of these is love, which is the overriding power of Christ that birthed us and delivers us into the promises of God. Isn't that beautiful? When we live this on a moment-to-moment basis, we are establishing ourselves in eternity, and we are sure of what's going to come to pass. And so the present doesn't bother us so much. We don't live in the present. We live in the present expectant for the future, right? Amen. C.S. Lewis has a very, very interesting quote on this. See if you can grasp this. I'm not sure I did. That's why I want to say it. He said, "The mold in which a key is made would be a strange thing if you had never seen a key. And the key itself a strange thing if you had never seen a lock. Your soul has a curious shape because it is a hollow made to fit a particular swelling in the finite contours of the divine substance, or a key to unlock one of the doors in the house of many mansions. Your place in heaven will seem to be made for you and you alone because you were made for it. Made for it, stitch by stitch, as a glove is made for a hand." C.S. Lewis. Isn't that amazing? Your place in heaven will seem to be made for you and you alone because you were made for it, stitch by stitch, as a glove is made for a hand. So we do not hope as the world hopes, with much uncertainty. We have been given a better hope. Hebrews 7:19, by which we may draw near to God. Isn't that a beautiful thing? So our eternity, our perspective on eternity, is the overriding idea that must sink deep into our hearts and souls to carry us through difficult times. So let's spend a few minutes talking about pain and suffering. Pain and suffering gets us in touch with our powerlessness like nothing else can. Everyone feels benevolent if nothing happens to be annoying them at the time. Isn't it true that we all feel caring when there is nothing at stake personally? But when it hits home to our own self or another one of our loved ones, it becomes an immediate challenge to our belief system and what we have expected from life. C.S. Lewis again says, "The human spirit will not even begin to surrender self-will as long as all seems well with it. Now, error and sin both have this property, that the deeper they are, the less the victim suspects their existence. They are masked evil. Pain is unmasked, unmistakable evil. Every man knows that something is wrong when he's hurting." So that being true, the question is, what is wrong? What is our response to this evil and the wrong that has assaulted us? Again, C.S. Lewis offers an answer to an age-old question: why me? This one kind of took me back. He says the real problem is not why some pious, humble, believing people suffer, but why some do not. And I thought about that and I said, oh my goodness. The Bible, of course, is replete with people who have pain and suffered and gone through all kinds of trials and tribulations. So why should I be exempt? Why am I sitting here saying, why me? It doesn't make sense in the context of biblical truth, does it? So you see, if we consider the Bible and the characters that God uses as examples to teach us with, it's replete with tragedy, trauma, sickness, and sadness. So what is our biblical response? Well, simply, we could say Christ-likeness. The suffering servant, Isaiah 53. The good shepherd who lays down his life for the sheep. Henry Nouwen said this: the inner life is always a life for others. Pain in ourselves or our loved ones is opportunity. Now, I've been getting away from my fill-ins here, I'm sorry, but we're pretty much on the second page. Pain and suffering. Pain and suffering gets us in touch with what? Right? And then the real problem is not why some pious, humble, believing people suffer, but why some do not, right? And so number 3 is pain is opportunity for ourselves and for our loved ones. Could there be a biblical prescription for this? Well, in fact, there is. And it's found in Romans 5, 1 through 5. And I don't have time to go through the entire Scripture with the time we have. But the Scripture talks about this. It talks about suffering produces perseverance, and perseverance produces character, character, hope, and hope that does not disappoint. Remember, we talked about hope, the positive expectation of something that will happen. So suffering has a purpose. Suffering produces perseverance. Perseverance produces character. Character produces hope, and that hope does not disappoint. Now, I can't, again, go through, with the time we have, all the Scripture, but Psalm 116 is a wonderful psalm, a psalm for continual meditation, I would say, as we develop this biblical perspective. It starts like this: I love the Lord because he has heard my voice and my pleas for mercy. The Lord hears. The Lord cares. So I recommend Psalm 116 to you. So let's talk about a few really practical things. Isolation. Isn't one of the tendencies to be alone and feel like you're the only one going through it? I think Samantha was talking about how, she would go between the hospital and the nursing home, but you would meet people. You see, isolation by nature is entirely contrary to anything holy. It was established in the garden. It is not good for man to be alone. Isolation was the final anguish of our Lord and Savior. What was his cry? My God, why have you forsaken me? Therefore, while we can and should embrace times of quiet solitude for a purpose of regeneration, we must reject any tendency or impulse to suffer alone. It robs us and others of the fellowship that Paul spoke about, the fellowship of his sufferings. And we lose the benefit of those who truly know what it is to feel and to know what we are going through. There is a very special thing that happens when we open ourselves up and share our sufferings with another, especially brother or sister in the Lord. And I heard this some time ago, and I hope it'll make you smile, but it's the banana that gets separated from the bunch is the one that gets peeled. Maybe that'll help you remember not to get isolated. Isolation is the devil's playground and feeds all kinds of negative feelings. Think about it. Come on. We've all been here. Helplessness, powerlessness, self-doubt, guilt. It's the devil's workshop. So at this point, I would suggest, does your church have a support group for caring people, people who are caring for the sick, their loved ones? If you don't, start one. It would be a great thing. Proverbs 11:14, where there is no guidance, a people falls, but in an abundance of counselors, there is safety. I'm sorry? Proverbs 11:14. Oh, I'm sorry, it's 11. Yes. Where to go? Where there is no guidance, a people falls, but in an abundance of counselors, there is safety. So let's talk about caring. Henry Nouwen again says, care is the loving attention given to another person because that person is a child of God, just as we are. There's an expression, I'm not even really sure where I heard it, but it's come in very handy for me at times of visitation, hospital visits, sickbed visits, deathbed visits. When you don't know what to say, it's called the ministry of presence. Your presence makes a difference, not your words necessarily. In doing all the stuff of caring, we tend to neglect the being there, and we devalue our presence in the situation. Your being there makes all the difference. When you're busy going back and forth trying to do stuff that has to be done, and it is an act of worship, I understand, and it's part of your caring, but you forget about just being there. Sometimes just stop all the doing and just be there. It makes all the difference. Being there counters the aloneness for the other person. We just talked about isolation, right? Your being there counters the isolation of the other person. Where do we see that? Mary at the cross. Everyone had deserted the cross, right? Except John. John was there. John with Mary at the cross. Find the gifts of fellowship in your time of need. Here are the gifts of fellowship. Community. What does community produce? Warmth. Sympathy. What does sympathy produce? Kindness. Empathy gives us that emotive response. Prayer. Restoration. Healing. Relief. Direction. Hope. And perspective. Vision. So I'm going to close with this, the 3 I's. We already touched on them, on one of them, I should say. The 3 I's are the loss of independence, the loss of identity, and isolation. And this goes both for the one who is sick and the one who is caring. Because the one who is caring also feels like they've lost their independence. Even though there's one in the bed who's bedridden, certainly does. But the caring person also feels that way. The loss of identity. Just I'm just thinking of young mothers. They often feel they've lost their identity because all they do is care for the little one, and their identity is completely wrapped up in that. And one of the funniest things a lady can say is, "I got to talk to real people today." But this comes back, doesn't it? When you're a caregiver, you lose your identity. It's very important to maintain your identity. And then, of course, isolation. Self-care in these areas keep you vital in the life of the one you are caring for. I've said a lot of things, and I hope they've been valuable to you, but I think this last thing is perhaps the most important, as a caregiver especially, and that is to face your own deficiencies. Did you create the condition your loved one endures? Can you cure them? Can you control what is happening to them? Answering these 3 questions, that is, what you can't do, leads to qualifying what you can do. God bless you. Thank you so much for listening. We'll do our tap in the meantime.
I would like to say that you both complimented, one side complimented the other. That was so, I think it would have been.
That was the master plan, or the master's plan.
And you could be here every week and it would still be great.
So that was beautiful, that it was balanced.
Thank you.
Such a beautiful balance.
Thank you.
Yep.
Thank you very much.
He's the brains.
What does that make you?
Both of the microphones are on, gentlemen.
Okay, great. So we're here for questions, of course, if there are any. I did receive a note with 2 questions I'll be happy to answer. The first question is in regard to the power of attorney. I referenced powers of attorney since 2010 being the proper form at this point. Those drafted and proper prior to 2010 are still valid. So the ones prior are not void because of the new law. The issue is, though, that they may not contain all of the powers and all the goodies that the new ones do, okay? But you're still fine if you have it, and if there's a loss of capacity and a new one can't be signed, you're still covered, okay? But if you have the ability to sign a new one, you should. The other question is, has the assisted suicide issue, I'll assume, has it come up, I don't understand the rest of the question, but just that concept, it depends what state you're in and depends on what's meant by assisted suicide. There is, through Oregon and the Northwest, there's been more of a freer movement in that regard, and it has kind of drifted eastward. The realities there are real sticky. I mean, assisted suicide is a difficult topic that a lot of people are divisive on. What we have adopted, what New York has adopted from out west, is something called a MOLST form. It's a medical orders for life-sustaining treatment form. and it's a bright pink fluorescent form that is meant to be filled out if somebody is terminal, which means 6 months or less. It is an active medical order that will follow the patient from home to hospital to rehab to nursing home to hospice, unlike a DNR, which does not follow the patient. In the beginning, I did not like the most form. However, seeing it in action, I've become more fond of it. And it's good for discussions and to start thinking about end-of-life issues. It is not assisted suicide, it is not euthanasia, it is not those issues. It's meant to be conversation. The reason I don't love it is it's a static paper form, and just like a living will is. And a person's wishes and desires can change. So the best way to deal with medical issues and end-of-life issues, I have found, is the healthcare proxy, that person himself or herself, because they're the ones that should be having an ongoing dialogue or making active live decisions based on that person's best wishes. So that is really, truly the best way to deal with those issues. All right? Yes, ma'am.
6 states already have legalized assisted suicide.
Yeah.
And Cuomo, one of my buddies, will support it.
He probably would. He probably would. Yeah. Again, it's a very sticky issue. As an attorney, I'm caught in the middle on a couple of these things because I deal with clients that I've had clients that have said to me flat out, if I'm in that condition, just take me out back, and that's not my call. All right. And I believe that as Bobby has shared, you know, we're here for a purpose. We're here for a mission. We're here for his purpose. And when it's time to go, he'll take me.
Right.
All right. All right. Any other questions, folks? Over here, we'll do the left one
Thank
first.
you. If I were to put my house in an irrevocable trust in Suffolk County, would I lose the senior discount on the real property tax?
Okay, so the question is, if I was to protect my house and transfer it into an irrevocable trust, would I lose my real estate tax exemptions? And the answer is no. All right. You have what's called the right to reside in the property, and that is what those tax exemptions are based on. Sometimes it could take up to 10, 11 months for the county to catch up to the fact that the house was transferred, and they may ask for a copy of the trust or a copy of that section, and that's common.
And just one follow-up, if
Yeah.
I were to put my house in the trust and then decide to downsize to a smaller place because I can't handle the house anymore, is that doable?
100% yes. The irrevocable trust has authority for the trustee to sell the home. Correct. So the home would leave the trust. The cash from the sale would go into the trust, all still protected as of day one. It's not a new 5 years. It's not a new look back. It's not another gift. And then that trustee can use that money to purchase another home. All right. You're welcome. The one caveat there is most co-op boards do not like these types of trusts. All right. So, but if it's a condo or a freestanding home, then it's no problem. Okay. Yes, ma'am.
Two quick things. Should you have a will and an irrevocable trust?
Okay, good question. They are completely separate, and the answer is yes. The question is, should you have a will, and I'm just going to say a trust, and the answer is yes. Whether it's an irrevocable trust for asset protection or what's called a revocable trust, which we didn't get into much tonight. A revocable trust is not a protection trust because it's revocable. And if I can revoke it and put the money or property back in my name and get it, well, then so can a creditor, so can a nursing home. So the revocable trust is not the protection type. But whether it's revocable or irrevocable, you always need to have a will separately. Okay, because the trust can only govern that which it owns. All right.
Okay, and then
Yeah.
one other quick thing for me. So many times I've heard people say, I don't need a will because I have nothing, or I don't need a will because my son will get everything.
Right,
You know, like-
right.
Could you comment on those?
Sure. So the question is, I don't need a will because I don't have anything, or I don't need a will because my son's going to get everything. May be correct at the end of the day, but it's not the best way to go about it at all. The will itself is where you have the opportunity to direct who is going to be an executor of your estate. It gives you the opportunity to determine how a person is going to inherit. It gives you the opportunity to determine when a person is going to inherit. Just leaving not having a will means you are allowing New York State to determine who is the executor, or what they call an administrator at that point, and who's going to inherit and when they're going to inherit. Not having a will can be devastating to a family. So there should always be a will, regardless if we're talking about $10,000, $15,000, or we're talking about $1 million. There's a will. Now, it's important to point out, a will only governs and distributes assets that are in the person's name alone, okay? When we ultimately pass away, there are 4 ways that we can own something. We can have something in our name alone. We can have something with a joint owner, like a bank account. We can have an account with a beneficiary, like an IRA or an annuity or a life insurance. Or we can have an asset in a trust. And if you have an asset in a trust, then that trust will dictate who inherits when the person passes away. So you don't need the court to help you at all. If you have a beneficiary on your account, the financial company will pay the money out to that beneficiary. You don't need the court to help. If you have a joint owner, the moment one owner passes, it automatically passes to that other owner. You don't need the court. If you have something in your name alone, then that's where the will comes into play. And as I mentioned earlier briefly, the will requires probate, okay? The will by itself is just a bunch of pages stapled together. It's not actually called a will until it's admitted to probate. Probate is a validity proceeding to determine whether or not the will is accurate and valid, or forgive me, just valid. The reality is the last will and testament is crucial to have, but we don't want our clients to use them. Not meaning we don't want them to die, meaning that we don't want them to have assets left in their name alone. We want all clients to avoid probate. Probate can be 7 months long, it can be years long. It gives everybody the opportunity to sign off on that will. So if you have a child that's being disinherited or receiving a lesser percentage, do you think they're going to agree and sign off and cooperate? No. They're going to drag their feet, they're going to get a lawyer, and it's going to take years. We've seen it, we've got it going on right now with siblings. In addition, if you have real estate outside of New York in your name alone, you've got a probate in New York and a probate in Florida, for example. So avoiding probate is always a goal, right alongside protection. So that was a long answer, but there you go.
No, thank you.
Okay. Yes, ma'am.
You named these 4. Could you repeat the last one you said, if you have it in joint with a trust?
Okay, sure. Well, there's 4 ways. Oh, that one's working.
Please, I'm sorry.
Both, they're,
That one is working? Yes, sure. So that one was, if I understood you correctly, ma'am, was what are the 4 ways that you can own an asset when you pass on? The first one is solely in your name. The second is joint with another person. Third is have a beneficiary. And fourth is to have the asset owned by a trust.
Jointly with somebody.
Joint was number 2.
No, but an asset in a trust, and then you can attach to the money, is that true?
Okay, so a trust is a written agreement. It's a separate entity from the actual person. It's like a corporation, if you will.
Right.
And it can own its own assets. It should have its own tax ID number, perhaps, and its own separate entity. So if Joan Smith created a trust, it would be called the Joan Smith Irrevocable Trust. And that entity would own the account, and that entity would distribute the account after Joan Smith passed away.
And if there was no will, and this existed in number 4, what happens then?
Okay, so if there's no will and the person had a trust, we've had clients with all 4 types of assets. You can have a bank account in your name alone. You can have a CD joint with somebody else. You could have a life insurance policy with a beneficiary, and you can have a house in a trust. The trust will govern the house only, because that's what it owns. The life insurance will go to the beneficiary. The CD will go to the joint owner. The bank account that's in the person's name alone will go through the will.
And this was my question.
Well, that wasn't even the question.
No.
Okay.
If there is no will, and the person was married 10 years, is there a stipulation on how many years? As long as they got married 1 year and there's no will, they get all the money, is that correct?
Okay, so the question is, if a person is married, is there, whether it's a year or longer, is there a stipulation or a law that says they inherit everything? And the answer is no. All right? New York, if I understood you correctly, and I'll answer it, but correct me if I'm wrong, New York has you're not allowed to disinherit a spouse in New York. Okay? So if you are married when one of the spouses passes away, all right, then that spouse that's surviving is entitled, if they file papers for it, entitled to at least a third of the estate. It's called the right of election. Okay? Now, in certain Medicaid cases, we actually disinherit the spouse on purpose. All right? But think about it. So if we have, right, but it does happen intentionally in some circumstances, and then it happens in other circumstances where, you know, one's just not doing the right thing and you're trying to disinherit. In those cases, then papers can be filed to receive at least a third. But nowhere is it where you can inherit everything.
The other 2/3.
Then it would go to whatever the will or other...
There is no will.
If there's no will at all, okay, let me talk about that for a moment. So if there's no will, what happens? It's what's called intestacy. And every state has this set of laws. And intestacy says if I pass away with something in my name alone, then it will go to my spouse and my children. If I don't have children, it goes all to my spouse. If I don't have a spouse, it all goes to my children. If I don't have a spouse or children, it goes to my parents. If I don't have parents, it goes to my siblings. If I don't have siblings, it goes to my nieces and nephews. If I don't have nieces and nephews, it goes to my grandparents. They're not there, so then it goes down to my cousins. So there's a whole setup as to where everything goes. And if there's nobody there, then it goes to New York State. So having a will is...
So cousins are included in this.
As long as there's nobody above them. Okay?
Would you repeat the sequence again?
Sure. It's spouse and children come first. It's always spouse and children. Okay? If there's no spouse and children, then it's parents.
The parents are dead, the grandparents are dead.
Are there siblings?
Yes, one sister.
Then she gets it all.
Why?
No, we started off by saying the spouse and the children get it first. If there's no spouse and children, then we go, then the spouse gets everything. If there's no will,
Contesting. Anything.
no, that spouse, if there's children,
Nothing.
okay, if it's just a spouse, then the spouse gets everything. There you go. That's where the spouse gets everything, if there's no will. Okay? Okay. Where should I send the bill for the consultation? To the spouse. There we go. The sister. There we go. Okay. Yes, ma'am. Okay, great question. What is a life estate? A life estate is another way to protect your home. All right? It does not work on any other type of asset. It's just about your home. It's a simple way to protect your home. It's not the best way to protect your home. We used to do we used to do a couple of them a year. Well, I should say, we used to do maybe 10 to 15 of them a year. For the last, I'd say 8, 9, 10 years, we do maybe 3, maybe 2. The reason we don't like life estates is because the irrevocable trust offers much, much more, okay? A life estate is a one-page deed where mom and dad can say, I want to protect my home. So they sign the house over to one child or to 5 children. And mom and dad keep the life right to live in the house. That's the life estate, okay? The children are called the remaindermen. They get the remainder. They get what's left after mom and dad die, okay? So it's a very simple one-page form. The reason we don't like it is because of contingencies and risks, okay? If something, let's say there's 5 children on the deed with mom and dad have the life estate. If one of those, and we've seen these things happen, if one of those 5 children should pass away, now, and they had a spouse and children, that spouse and children are now involved with the other 4 siblings, all right? And if you have a minor child, now you're going to get the court involved because you need a guardianship appointed over that minor child because they're under 18 and not an adult. So you don't have a lot of flexibility there, all right? In addition, it can be very difficult to change if something happens to one of the children. So, for example, if when you do the life estate and give the house to the 5 children, everybody's healthy and in good marriages. But if, God forbid, something happens 8, 9, 10 years down the road, you're stuck for most life estates. Whereas the irrevocable trust isn't a one-page document, it's a 45-page document with a lot of contingencies built into it. So the trust actually says, if one child passes away, then this happens. And if there is a minor child, then the money gets held over here until they're 25. And if they need the money, they can have it. Or if one of my children or grandchildren is disabled, then the money goes over here and it gets protected. And you can always change the beneficiaries. So if you see a child with a bad marriage or incarcerated, you can actually change the way they inherit. All right? So the trust just has a lot more flexibility to it. All right? Does that help? Okay, good. All right. Yes, ma'am.
Community Medicaid.
Yes, ma'am.
We're going through some conversation in our family right now.
Okay.
And there's a confusion in reference to the community Medicaid. There's a thought that they need to change doctors because of the word Medicaid, that their doctors need to accept Medicaid. That's false, is that?
Right. So the question is, if somebody is on Medicaid, do they have to change their doctors? And the answer is false. The scenario is false. You do not, because if you go back to my discussion, Medicaid is there. It's what's called the payer of last resort. It's there for the chronic needs. It's there for the aid. It's there for the nursing home. Sorry. It's not there for the medical needs.
For daily living.
That's the Medicaid, right? So if somebody has a doctor or a hospital or an emergency room need, then you're still using Medicare. You keep both.
There's a big controversy.
Well, shoot me an email and I'll answer it. Okay. And, yes, ma'am.
For the pastor, do you feel that it's okay for Christians to be cremated?
Wow. Yeah. It's a tough one.
It is a tough one. I believe that it's okay in the sense that we don't know what we will look like in eternity, okay? God will make everything new again, okay? So can God do it with dust and ash, or can he do it with a decayed body?
Yeah.
I think he can handle both of those scenarios.
Yeah.
So-
And I haven't seen, just from my little research, I haven't seen anything, I've read articles on it, I haven't seen anything prohibiting it,
Right.
at least in the articles I've read.
Right.
I think it's more actually in the Jewish faith.
Well,
Yeah.
that's where it's, right.
Oh, yeah, absolutely, absolutely.
Some
Yeah.
Greek Orthodox do not.
So,
Certainly, there are different
Of course,
opinions on it, absolutely,
right.
sure.
right.
They're vehemently against.
Yeah.
Yes, sir.
Question, let's say you set up all of this, you're living in New York, what happens if you move to, say, Florida? How much does that?
Okay, so to repeat the question, if you establish a plan in New York and then move to another state, two answers, the practical and the technical. The technical answer is that if it was done validly in one state, it should be valid in another state. Okay, the practical answer is, and we tell everybody this, we can recommend or find an attorney where you're moving, you have them look at it. All right. In particular, the power of attorney is very state specific. So we always tell people you're definitely going to have to update the power of attorney. On the other practical side, for example, an irrevocable trust in New York. All right. Great tool. We use it every day. It's also available in Florida, but you need it tweaked a little bit because they have homesteading for their homes down there. So things need to get modified a little bit. All right. So you should have somebody look at it. All right. Yes, ma'am.
For the pastor, hi, I just wanted to say that the Blessed Mother told the visionaries at Fatima that nobody is over the age of 33 in heaven, because that's the age that Jesus died. And she showed them heaven and hell. And one of the missionaries says, "Why is my mother so young?" And she told her that.
Interesting.
So we're all going to look younger and more youthful.
From your lips to God's ears.
There you go. Right. There you go. That's it. Any other questions, folks? I wasn't joking before. If there's questions, please give me a call on the legal side. Don't call me on the pastor side. And I'll be happy to answer. Just if you call the office, just say that you were here to talk, and we can figure things out, okay? Again, thank you all for coming. Thank you,
Yep.
Bob.
Thank you.
Thank you, Samantha. All right.